Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. Today I'd like to talk to you about a very important issue, and that is the new law that allows you to arrest an individual for DV for up to 7 days if the person was not at the scene at the time that officers arrived to investigate the DV. And as I am told, officers are given a list of individuals and their addresses to go to the residence every day and arrest the individual. I'm telling you here today that you should not do that. And I'm going to get into the case, but unless you have an arrest warrant, you cannot go up to a person's house under these circumstances and make a PC arrest. You cannot go and do a knock and talk as a guise to get the person out of the house and arrest him for DV. So don't try any of the workarounds, and let's talk about this case. And so the case is Brula versus City of Sparks. It's a Ninth Circuit Court of Appeals decision that came down in August of 2023. And the facts aren't entirely clear from the opinion, but apparently officers went to the suspect's residence to do a knock and talk and presumably arrest the individual, although that isn't entirely clear. And while officers are there, something occurred and the individual was shot and killed. And his family turned around and filed a lawsuit against the officers for violating the individual's civil rights. And in that case, the district court found that there was sufficient evidence to move forward with the litigation charging the officers with violating the individual's civil rights. And the trial court also refused to give the officers qualified immunity. That is huge. And so as a result, the case went up to the Ninth Circuit Court of Appeals, and the court said the trial court judge was right. There was sufficient evidence that the officers violated the individual's civil rights. There was sufficient evidence that the officers violated clearly established law, which means that they aren't entitled to qualified immunity. And so here is a portion of the decision. We agree with the district court that no exception to the warrant requirements apply here. Reasonable suspicion and probable cause, absent exigent or emergency, are insufficient to justify a warrantless search and seizure on the curtilage of the suspect's property. Even assuming the officers had probable cause to arrest Brula, the record does not demonstrate that an exigent or emergency circumstance existed here. The officers had not chased Brula to his home, nor was this a case of hot pursuit. The knock and talk exception for a warrantless search, which permits law enforcement officers to encroach upon the curtilage of the home for the purposes of asking questions of the occupants, also did not apply here. The exception only is contemporaneous with the implicit license to approach the home and knock. Here, Brula did not consent to being questioned on his front porch and repeatedly asked officers to leave. The officers detained Brula on the curtilage of his home without a warrant or probable cause and questioned him while he repeatedly asked them to leave. Thus, the district court did not err by denying qualified immunity to the officers and granting summary judgment to the plaintiffs on the Fourth Amendment unreasonable search and seizure claims. So let's backtrack for a second. Under the Payton rule that if you're going to enter an individual's residence, you have to have a warrant. That's the Payton rule. We all know that. Well, we also know from the last several years that the U.S. Supreme Court has recognized that the curtilage of a person's home is part of their home as well. There was a U.S. Supreme Court decision where they held that officers violated the Fourth Amendment by going onto a person's property to search the VIN number of a vehicle they believed to be stolen. On another case, the U.S. Supreme Court decided that a trooper who had followed an individual home who believed to be impaired and arrested him for DUI in his garage violated the Payton rule as well, because it was an arrest on the curtilage of the individual's house. And so the bottom line is this: when you are directed to go to a suspect's home within 7 days after the alleged domestic violence incident, you're going there without a warrant and you are violating that person's civil rights. Some have said, well, why don't we just do a knock and talk under the guise that we're going to find out his side of the story and maybe we won't arrest him. Well, a court is going to see through that because you'll be cross-examined on what the circumstances of the alleged incident were, what circumstances would convince you not to arrest the individual. And so that's just no bueno. A court is going to determine that you're not credible. You'll be sued for civil rights. You won't get qualified immunity. And you may be found to be untruthful by the court, which means that you'll be put on a Brady list. And anytime you testify in court in the future, your testimony will be subject to question. And of course, we know that if you are untruthful, you'll be disciplined by the department and maybe even terminated. So for all of those reasons, when you are directed by a supervisor to go and knock on an individual's door who there's probable cause to believe the person committed domestic violence, stop. You can go to the person's residence. You can set up surveillance if the person's bad enough and you want to take the time to set up surveillance outside of the house and pull the person over in a vehicle, but do not go up to the house. I know that this is contrary to what some officers have done in the past, but I'm telling you this because as your lawyer, as your PPA lawyer, I don't want to see you get sued and have your career ruined. If you have any questions, please contact me at droger@lvppa.com, and please stay safe.
111, 110.